I believe we still have Julius Kim standing by, if we can go back to him as well for more legal analysis about the work the state really had to do here. And Julius, of course, the burden of proof is on the prosecutors in a criminal case like this. What did you think of the job they did, really taking the jury foot by foot through the parade route and connecting so many of the dots of what and where Darrell Brooks was and what he was doing before and after the attack?
I think they did a great job. There was not a lot of issue with regard to the provability of the case, in my opinion. And from a technical standpoint, I don't think that there was an issue with regard to ID and that type of thing. I think that this was a logistical challenge for the state, in all honesty. There were so many counts that were charged, so many witnesses and victims that they needed to account for and manage during the course of this trial. They needed to work with a lot of evidence, hundreds, if not thousands, of reports and digital evidence. So they did a really nice job compiling the case together and presenting the case in a very logical way. I thought that one exhibit with all of the victims' names on them along the parade route was very effective. I thought that the way they presented the case was effective and it made sense, and chronologically it was easy for the jury to understand. So kudos to the state for doing a good job in terms of organizing the materials, presenting the case in a very clear fashion, and in their closing arguments, not over-prosecuting the case. They knew they had a strong case, and towards the end of the trial, they didn't over-prosecute the case by prolonging this case getting to the jury longer than it had to.
As we continue to get reaction from those who were in the courtroom, those who have been affected by the losses, let's jump ahead to Monday, when the judge has said this is going to be a time to schedule when the sentencing will happen, and finding out how many people want to speak, give victim impact statements. There's 76 counts. Could 76 people be allowed to speak, or how does that work?
Yeah, they have the right to do that. But I'm not sure that all 76 people and all interested parties are going to actually make a statement. There's also the option of submitting statements in writing, and I think that the state is going to encourage that as well. I know Judge Darrell is going to consider everything, whether it's written down or statements being made via Zoom or in person in court. The reality of the matter is that Brian is absolutely right that Mr. Brooks is now facing 6 life sentences, and I just want to qualify that by saying that each one of those sentences is mandatory. So as soon as we heard the verdict on the first count, he was guilty of first-degree intentional homicide, as far as I was concerned, it was a done deal because it's a mandatory life sentence here. There's really not too much for Judge Darrell to ponder here. That's just whether she wants to run these counts consecutive to each other or to add on to a life sentence already. But life is life. Even one count mandates a life sentence for Mr. Brooks.
And if I may, the 6 people who were killed, they are Jackson Sparks, who was just 8 years old. He was a member of the Waukesha Blazers. Jaden Coolidge, 52 years old, walking with her employer, Citizens Bank. 4 members of the Dancing Grannies. They were Virginia Jenny Sorensen, who was 79 years old, Leanna Owen, who was 71, Tamara Durand, who was 52 years old, and Willem, who went by Bill Hospital, who was 81 years old. He was a husband of one of the dancers.
Julius, throughout this case, obviously, Darrell Brooks spent a lot of time on the sort of sovereign citizen issues, raising questions of jurisdiction and refusing to respect that the court had jurisdiction over him. He's not the only person out there who's using these sort of sovereign citizen arguments in court. There are more of them out there. Is this having any success? Did we learn anything from this case as to how to handle disruptive pro se defendants making these kinds of arguments? What's your takeaway on that?
Yeah, with regard to the sovereign citizen stance that Mr. Brooks and a lot of people have been taking, I think that this trial is probably a good lesson in terms of how the court system is going to deal with it. They're going to ignore it because the laws in Wisconsin don't recognize this whole sovereign citizen thing. And you can see how far that got Mr. Brooks. I think that this was all kind of new territory for the state and for Judge Darrell, quite frankly, because this was a high-profile case and one where we had a pro se defendant claim sovereign citizenship, which is unusual in and of itself. And I think that Judge Darrell handled it as best she could. She acknowledged certain things, but she also moved on, acknowledged the objections, acknowledged his positions, but ultimately told him that's for the Court of Appeals to decide, and I'm moving forward with this case.
You know, I've been talking about this just off the air with friends and colleagues and family members about whether or not what's happening with this case is the type of thing that'll be discussed in law schools in the future. I mean, is this case going to be something that will be studied in terms of how Judge Dora handled not only a pro se defendant, but a very disruptive pro se defendant?
Yeah, I think that's a great point, Brian, because I think all of us kind of knew what the end result was going to be in this trial. I was watching this trial more for those things. You know, how does the criminal justice system deal with pro se defendants? How does the criminal justice system deal with defendants that have mental illness? How do you deal with defendants that are disruptive in court? And we could see how Judge Darrell leveraged technology to her advantage. You know, 10, 20 years ago, I'm not sure that this trial would have looked the same way. We could have very well have seen a bound and gagged Darrell Brooks in the courtroom 10 or 20 years ago. I've seen those situations happen, but because of technology, those things didn't have to play out. So this trial definitely is going to be conversation for lawyers, for jurists, for judges, and in classrooms all around for a long time, because there's a lot of lessons that can be gained from watching how this all played out.